Morning. This is Division 10 with the Honorable Tangela Berry presiding.
This is an emergency status hearing that the court is having on 22 FM 8022. This is the matter of Way versus Thomas. I received an emergency motion indicating that Mr. Way was anticipating or trying to leave the jurisdiction with the child. And essentially, I wanted to understand the truth of that allegation.
Your Honor, if I may, I think Attorney Montgomery was speaking as well. She's on mute.
She's on mute. Mm-hmm.
Okay, I'm sorry about that. Okay, Your Honor, since it's my motion, Attorney Holloway, if you'll allow me
Sure.
to proceed, and I'll, obviously I'll give you an opportunity to respond. I was contacted by Ms. Thomas Way earlier this week. I did make attempts to contact Attorney Holloway. She was not available at that point in time. The information that was given to me was that the father was seeking to leave the state of Georgia to go to the state of Illinois with the child. That is one of the instances where I felt that there were grounds for an emergency proceeding before the court today. But I would like to take the courts back. We were here before the Honorable Court, I believe on March 25th of 2024. During that time, the parties did speak, the counsels did speak with the court, and the court ordered that moving forward on that day, that there would be a 2255 schedule for the older child, and then mom would continue to have primary custody of the younger child. And that order was going to be prepared by Ms. Holloway. The child support worksheets, the courts requested 2 child support worksheets, one for both children.
Okay, let me, I'm in the middle of a trial.
Okay.
Is this child being moved from the jurisdiction? Yes or no? I don't want to deal with any other matter because those things I can deal with another time, literally in the middle of a murder trial.
Okay.
Is there a movement of the child from the jurisdiction?
Your Honor, if I may respond, no, there is not. Mr. Way had a family emergency. He wanted to leave on Monday so that he can go to Illinois to make funeral arrangements. He was going to return on Wednesday. However, Mr. Way is currently recuperating from back surgery. His doctor told him that that was too long of a trip for him to make. And so Mr. Way never went to Illinois to make those funeral arrangements. He has no intention of moving at all.
All right, then. So that's the only issue that I needed to address immediately. All other matters will be.
There's one more issue, Your Honor, that Mr. Way or Mr. Thomas is using the previous order to contact the police, make false statements. The child is not re-enrolled in school, and he has obstructed the mother from having visitation with the child.
The child is not in school?
No, the child is not.
Your Honor, if I may respond, that is correct. The child is not in school. Mr. Way has been in touch with DeKalb County. They admitted that they erroneously disenrolled her. Mr. Way, she's actually attending the school Mr. Way works at. I sent to opposing counsel the paperwork that Mr. Way has sent to the school so that she can be re-enrolled. That was last month. It was my understanding from Mr. Way that she was supposed to be permitted to attend school on this Monday. However, the minor child has expressed suicidal ideations, and she is currently in Ridgeview, and she's expected to be there for the next 5 to 7 days. So I'm unsure if she will go to school on Monday, but Mr. Way has completed the paperwork. I've sent that to opposing counsel, as well as his email communication with the enrolling specialist at the school so that she can return to school in DeKalb County.
Mr. Thomas Way also
and she did, and I may, just to the part about obstructing, the oldest child did visit with Miss Thomas March 27th through April 8th.
So visits are going?
No, they are not.
Okay, but she's in Ridgeway now, so obviously they're not.
Right.
She had the child from March 27th to April 8th. Is that right?
Can I speak?
I don't know. I'm asking first.
She had it from March 27th to April 5th. I had both. Yes, I got Sherry on the 27th of March, and I went that Friday when I sent on the 27th, and I got Sherry on. I tried to get both of them that Friday, and Kayla said it was her weekend to be with her mom. I said that, like I explained to Kayla, if you stay with your mom, you get 1 weekend with me, 1 weekend with your mom, and I let her go back. And me and Sherry went to Tennessee. And so when I came back, I let her stay a little bit longer. She wanted to stay with her mom. And because I said I talked to the grandma, and the grandma was the one that was doing arrangements for me to pick her up. And me and the grandma agreed on Friday at 5 o'clock we would pick her up. And when Friday came, I tried to contact the grandma. The grandma blocked my number, was texting, all kind of stuff. And so I had to call at that point because
I'm sorry. Yeah, that's way too much information for me. April 5th, from March 27th to April 5th, your position is that Miss Way had both children.
She had one. She had Kaylee from the 27th to the 5th. I had Sherry on one weekend, then I took Sherry back home, I think on a Tuesday, and I got both of the kids on the 5th, and I had them all the way up to the 8th because they was out of school Monday.
From March 27th to April 5th, she had children.
She had Kaylee, and Sherry came.
So why would she have Kayla and not Sharia?
Sherry didn't want to stay with her. Sherry came with me.
And Sharia is the youngest one that she has in her primary custody. So she got the oldest one from dad on March 27th, and she had the oldest until April 5th. The youngest went with dad to Tennessee that weekend.
All right. So your position is that, but for her being in Ridgeway, you would be honoring the plan that the court set out.
I've honored it. Yes, I have.
My client has no access to school because he's using the old order showing that my client does not have rights to the older child. She is unable to access school records. The school will not speak to her because he continues to use that old order, saying that he has primary and sole custody of the older child. He has contacted the police and told the police that my client is not allowed to have any access to the older child as well. The police actually tried to speak with me about the case because he had called the police on my client. So
when did he call the police on your client?
On the 4th, April 4th.
He called the police on April 5th because she would not turn Kalia back over to Mr. Way. In fact, she had Mr. Way blocked. So the police officer called from their phone and spoke to Miss Thomas. He showed the order to show that Kalia was supposed to come back with him because they would not answer the phone and they would not release her. That's when he showed the order to the police.
Okay. Was there the order that the court has hold on, I have an order, emergency hearing. Why not show this order?
So, Your Honor, there isn't an order. You asked me to draft it, which I did. Opposing counsel said that Ms. Thomas was not receiving child support. I've been trying to research that issue. Because I don't have a financial affidavit from her until yesterday. So there was no way for me to calculate new child support. Mr. Way is currently on child support. It appears to be an administrative order. It's not in the DeKalb system, but he sent to me yesterday the screenshots of all the payments that he's made to child support. So I can definitely put that into the order. The rest of the order was drafted. It's just this one child support issue I've been trying to figure out. But opposing counsel said Ms. Thomas is not receiving it. Mr. Way has all of the documents to show that he's been paying it. So I don't know what's going on with child support. Was child support already ordered in another matter, or was it something I ordered in this case? It appears to be ordered in another matter. I guess she filed for child support while they were separated because it's not attached to a divorce or anything like that. So that could be why I cannot find the order establishing the amount. I just have his receipts showing what he's been paying. The child support, is there a child support order, separate order? And that's what I cannot find.
No.
Is there?
Your Honor, you had ordered me to prepare the child support worksheets, and I have, and they were submitted to opposing counsel. I have been waiting for the order from opposing counsel so that we can submit it to the court for your signature. That is the holdup. We do not have the order. She said it's been drafted. We don't have it. That's the issue.
Okay,
and
so I asked you to do the child support portion of it and submit it to Ms. Holloway.
And she has it.
Okay, and so in the child support order that you—
I did 2. You asked for 2.
And so Ms. Holloway, why haven't you submitted those?
I got the child support order yesterday. These child support worksheets yesterday.
Your Honor, we've been asking, and I have the emails, we've been reaching out to Ms. Holloway's office for since March 25th, asking for the order, and she has not responded. She has not been responsive. And I understand that Ms. Holloway may have other cases, but I absolutely have reached out to you multiple times asking you to please send me the order to review. So
and I'm not saying that you haven't. I have the order drafted. I'm just saying that the holdup was the child support worksheets that I didn't get until yesterday.
You
But
didn't
child
ask-
support
you
has
didn't say
already
there
been,
was a holdup.
child support
Okay.
has already been filed. We discussed this yesterday.
What do you mean? What do you
finally
mean?
spoke yesterday. The
Okay,
first
wait a minute.
time we
Wait a
spoke.
minute. The child support worksheets were done anew. So you're saying
Correct.
previously I said, we're gonna do this anew. So there may have been another child support order, but we redid it.
That's correct.
Okay. And in that child support worksheet, you gave both of them to Ms. Holloway, so she now has it.
Yes, she does.
Okay, so Ms. Holloway, you can now incorporate that into your order.
Yes.
When
Yes, I can, Your Honor.
that order to me.
As soon as we get off the phone. Like I said, the rest
Okay.
of it's already drafted.
Go ahead and take care of that. Send that to me so we can take care of that as well. All right. And any other matter that you have, just file it. It's, for me, I was stopping trial because I want to keep the child in a jurisdiction to the extent that was the case. Okay, since that does not appear to be the case, drew the order, all other matters I'll take up later. All right, thank you.
Right.
Thank you.